Introductions by members. Member for Children and Family Development.
Speaker, earlier this month we lost a cherished resident of Machosen. Lally Baring Gould was born in Glasgow in Scotland in 1939. After completing her BA at UVic, she met her first husband, Smokey, and they had 2 sons, Ben and Nathan. In 1975, she married Bill and settled in Cordova Bay. In 1992, she moved to Machosen. Lally was very much dedicated to preserving the rural character of the district and other environmental issues. She had a very extensive network of family and friends. She touched very many people and always welcomed visitors to her house. There'll be a celebration of life in April, and I would ask everybody to join me in sending our condolences to the family.
Thank you. Madam Clerk.
Introduction of bills. Orders of the day.
Government House Leader.
Thank you, Honourable Speaker. In this chamber, I call Committee of the Whole for Bill 12, the Intimate Images Protection Act. And then in Committee A, I call continued debate on the Committee of Supply for the Ministry of Forests. And in Committee Room C, call continued debate in the Committee of Supply for the Ministry of Environment and Climate Change Strategy.
Committee chairs.
We'll call the committee to order. Shall Clause 1 pass? Recognizing the member for Abbotsford West.
Thanks, Honourable Chair. And just before we pick up again with the last remaining, I think I've got a question about 1 or 2 more of the definitions, and then we'll be able to move out of Clause 1. But I wanted to ask this. In the case of a piece of legislation like this that is tied fairly closely to the work of the working group at the Uniform Law Conference of Canada, my recollection is that in terms of the processes within the government of British Columbia, and this likely predated the President Attorney General's arrival on the scene, but this would have still, the decision to move ahead with this legislation would have still triggered the creation of a what we call an RFL, or a request for legislation, that would have made its way to Legislative Council to be turned into a piece of legislation. Is that correct, and is that the process that was followed in this case?
Attorney General.
Yeah, it did. It followed the process that we have here for creating legislation in BC with an RFL.
Member.
Thanks. And to be clear, that involved the creation of a request for legislation, RFL, and the involvement of Legislative Council. And the third part of that question, Legislative Council is still housed within the Ministry of the Attorney General.
Minister.
Sorry. Yes to all of them. All of those questions.
Member.
Thanks, Honourable Chair. The next term that is, I suppose, arguably one of the most important in the body of legislation before us is the term intimate image, and much turns on what the Act deems to be an intimate image. And it's here that we see reference to notions of altered images and also unidentifiable images. So if I can break this down a little bit, when one reads some of the commentary from the Uniform Law Conference of Canada report, it makes reference, obviously, to the definition, recommends a definition of intimate image, and that recommendation included what the government and the attorney have done, which is include in the definition a reference to an altered image. So for the record, an intimate image is, quote, a visual recording or visual simultaneous presentation and representation of an individual, whether or not the individual is identifiable and whether or not the image has been altered in any way in which the individual is depicted, and then it lists 5 ways that an individual can be depicted. I won't read that out just yet. In deciding and recommending, and the government has accepted this recommendation around altered images, the working group of the Uniform Law Conference spoke about the increasing incidence of altered images, video or sound, and it used a term, and the term, I've heard others use it, and I hadn't heard the term before, but it seems to be a key part of this, called a deep fake. The simplest question I can ask is, what is that, and what is its relevance to, although the term is not used, those recommending the language in this definitional section very much had a deep fake in mind when they recommended this language.
Minister.
Thank you. So a deep fake is when an image of somebody is taken, altered, and made to look like the person is doing things with blinking eyes and moving body in a way that's not there. So the use of technology right now makes it so deep fakes can be very accurate in terms of how it shows up to look like the person, but the person is doing things that they never did. And the definition, this is an example with altered images where we took the Uniform Law Conference's legislation and we went through a rigorous consultation process here, and we added things to our process and to our content to make it the most up-to-date as possible. So the altered images provision is meant to include things like deepfakes.
Member.
Okay, well, thank you. And in terms of the things that were added, are those the specific 5 subsections included in the? Is that what the attorney is referring to? Sub A, engaging in a sexual act, B, nude or nearly nude. Is it when she says the government chose to add things to that definition, does she mean add specificity as laid out in subs A through E of the section?
Minister.
Yeah, so there are some modifications between the bill, the model bill that the member was referring to, and what is before us today in terms of specific language. Some of it's convention and some of it is addition through our process. And we can go through specific ones it's evident when you compare the two, but if you have specific questions, I'm happy to answer.
Member.
Thanks, Honourable Chair. Well, I won't ask the general question because I think that's unfair, but as it relates, and it'll be a bit unwieldy if I ask that now, but as it relates to the definition of intimate image, this really key core defined term, can the minister summarize what she sees as the significant differences between what the Uniform Law Conference was recommending in its model legislation versus what is here?
Minister.
So the most significant addition is simultaneous representation. So you'll see in subclause E, simultaneous representation, which is meant to to capture things that are taking in real time and streaming, like with TikTok or some of the other ways that things show up on media platforms. That's one way. There are other ways throughout that are worded differently between the two, but that's the most significant policy addition that we saw needed to be added to the definition.
Member.
Thanks, Honourable Chair. What old guys like me would still refer to as a live broadcast would be a simultaneous transmission. All right. All of us have seen examples of photographs or videos where someone's face might be obscured, and the technology to do that has evolved, and it's apparently relatively easy to do now. That would qualify and be covered as an altered, or could qualify as an altered intimate image within the meaning of this definition.
Minister?
Yes.
Member.
The second part of the definition that someone, a layperson at least, and maybe even more than a layperson, would pause to consider is the decision in the legislation, and again, to be fair, flowing, I suspect, from the recommendation that was contained in the Uniform Law Conference, to capture in the provisions of the Act, the key phrase in the definition is whether or not the individual is identifiable. And on the surface, a person might say, might conclude, well, if the person is not identifiable, then where is the risk? Where is the risk of harm in a piece of legislation that examines the issue from the victim's perspective? So why don't we start there? Because I think it's in this day and age, and based on what we're told is out there and sometimes posted, the fact that someone, a claimant or an applicant, can proceed on the strength of a photo that is not identifiable, where the individual is not identifiable, might strike some people as, well, at a minimum, interesting.
Minister.
So a person who is not identifiable in an intimate image still has a reasonable expectation of privacy and can still bring an action under this legislation. That's privacy, sexual identity, and sexual objectification are all still issues of concern for a person depicted in a photo, whether or not their face is visible. Limiting the definition to identifiable images would focus too much on the reputational harm and fail to give consideration to the social harms, including invasion of privacy, loss of sexual autonomy, sexual objectification, and emotional distress. Unidentifiable people deserve the same protections as identifiable people because you can experience emotional distress in both cases. And we should also be mindful that over time, information can be pieced together or revealed in an image or established and can be, or at least to create a strong inference of the identity of a person in an image.
Member.
Thanks, Honourable Chair. I'll ask these few questions here, and then if I make the mistake of asking them again around clauses 5 or 6, the attorney will be entitled to say, well, we answered that, but also I won't purport to repeat the questions, because I think they're applicable in either of the sections. So a claimant or an applicant, and I probably should specify which, but I'll think about that for a moment while I'm speaking, comes before the tribunal seeking to avail themselves, well, let's say it's an applicant seeking injunctive relief in the first stage. It says to the tribunal, here is an intimate image that I am seeking injunctive relief or a takedown order, and on the surface at least, it's unclear that is at least for the tribunal, it is unclear whether that is an image of the claimant. At that stage, is the applicant, and the terms are important here. At that stage, is the applicant obliged to convince or prove to the tribunal that even though the image is not identifiable, it is an image of them?
Minister.
Thank you. So the relevant position or provision in Section 5 states pretty clearly that the applicant must satisfy the decision maker that the image is an intimate image depicting the applicant.
Member.
All right, well, that's pertinent and relevant. So the significance of that for the purpose of the definitional section is that people keep in mind, even though the image on its face need not be identifiable with respect to an individual, and we haven't talked about, so for example, an image of genital organs or region of the breasts, even though a third party would not necessarily be able to identify that image with an individual, that does not preclude seeking relief under the Act, but in seeking that relief, the applicant or the applicant needs to satisfy the tribunal that it is an intimate image of them.
Minister.
Yes.
The attorney referred a few moments ago in sort of broad terms the importance of the concept of reasonable expectation of privacy, and I take it that that is thematically what distinguishes much of the approach here, that the decision flowing from, again, from the Uniform Law Conference was to build this tort, this statutory tort around the notion of privacy as opposed to harm. And if I've got that correct, at the moment the attorney can confirm that. So meaning the reasonable expectation of privacy becomes a fundamental part of what an adjudicator needs to look at in terms of granting relief. Let's start by asking for the attorney and government's view of what constitutes a reasonable expectation of relief, and of course a reasonable expectation of privacy, sorry, in terms of what an adjudicator is going to look at.
Minister.
Okay, thank you. I'll start by saying that the reasonable expectation of privacy has kind of a rich series of case law when it comes to the common law all the way up to the Supreme Court of Canada. And that's ever evolving in different circumstances. What this legislation seeks to do is to clarify the principles of reasonable expectation of privacy and how they apply to the non-consensual disclosure of intimate images. For example, it establishes that your reasonable expectation to privacy is not lost if an image of yourself is distributed, or if you've distributed it to one person and that person then can distribute it to everybody. If you've only given consent to that one person and that person distributed, like it basically sets out the bounds when it comes to non-consensual disclosure of intimate images. So in that sense, it's clarifying the role of the reasonable expectation of privacy with relation to this matter.
Member.
Thanks, Honourable Chair. So I'm going to do something now, perhaps at my peril, because as the Minister says, the lens through which this legislation was drafted and being advanced is that of someone that is either been victimized or threatened with victimization. I will suggest this, that in the age we live in, and happily because of the views that society has properly formed against about those who would seek to victimize people, someone who becomes subject of a claim under this act is likely to, and perhaps appropriately, suffer some reputational damage, and maybe more than just that. So having some clarity around. So again, coming back to the working group's report, they discuss aspects of reasonable expectation of privacy, and make the point that the photograph of a person wearing a bikini on a public beach that subsequently is distributed, that in that case there likely isn't a reasonable expectation of privacy. At least I think that's what they suggest. You can take that example further, I suppose. A photograph of a person, I'm not sure what the right, topless bikini, or a person who is topless on that beach, who is then photographed in that photograph on a public beach, where that is distributed. So I don't think it's fair for me to ask the attorney to comment on every conceivable scenario that is out there, but it suggests to me that there are a range of factors that come into play, including the setting in which the image was captured. Is that a fair comment? Because I would say this: someone that captures an image in a very public setting and then posts that image would not want to find themselves on the receiving end necessarily of a claim, because although there are protections for the identity of the applicant or claimant, I don't think there are any such protections for the identity of the respondent.
Minister.
Madam Chair, I wonder if I could seek clarity from the member if we're now on section 2.
Member.
We're not. Although I understand why the minister, the attorney might think that, but the term reasonable expectation of privacy as it appears in the definition of intimate image, I am indifferent as to where we have this conversation and don't plan to repeat it in section 2. So.
Minister.
Under section 2 of the Act, it sets out reasonable expectation of privacy as to how it applies to this Act. And I can say that this is going to be an evolving area of law that's fact-specific, depending on whether or not they would find that reasonable expectation of privacy existed in that scenario. The member brought up some examples, so I think this one's illustrative in response to your example. So, for example, if a person is in a public park or on a beach, like you mentioned, there may be a conclusion that there's not, in general, a general sense of an expectation of privacy. But if there's somebody with a hidden camera or hidden lens or a telescopic lens, there's all these different forms of technology that captures images that exposes that person in a way that they're not exposed. For example, unfortunately, this happens of a person's skirt or something like that. Then I think that then you could see a court or a adjudicator deciding that has been tripped over to having an element of a breach of a reasonable expectation of privacy to it. So it's going to be just like the area of the law right now when it comes to reasonable expectation of privacy. It's going to be very fact specific and based on the scenario that's before the decision maker.
Member.
Thanks, Honourable Chair. I saw that, again, reference in the working group to the phenomenon of the minister has described of upskirting, which I take it is what she said, someone finding a way to manipulate a camera lens into people's intimate parts under their clothing. Would it be fair to say as a guide to the behavior of people that a photograph taken, a normal, unaltered photograph taken of a person in a public setting where others are observing that person in a public setting would generally not attract a reasonable expectation of privacy?
Minister.
So there's so many factors that could switch that over, so it's really hard to answer that question. Like, for example, if it was a nude beach, but it was roped off and said no pictures, right? That changes that scenario. So I just think it's really hard to draw a line around something without a full factual basis. But what I would say is that if there's any doubt, what we're trying to say is that you should have the person's consent before you take the image or distribute it.
Member.
I think the last question on this issue, in a circumstance where an image has been captured, let us say a photograph for these purposes, and it is captured in circumstances where an adjudicator would find that there is not a reasonable expectation of privacy at that time, and the image is subsequently distributed. Is the Act constructed in a way generally that would allow the person depicted in that image to argue the equivalent of this. Yes, I agree that at the time I did not have a reasonable expectation of privacy because I was on a public beach. I understand that. But I'm no longer comfortable with having that image, and therefore I wish to invoke my reasonable expectation of privacy after the fact and have that image deemed intimate for the purpose of the act and taken down.
Minister.
Thank you. So in one scenario, it's inherent in the definition of intimate image that the image, one of the components is that at the time the individual had a reasonable expectation of privacy. So I think that's one of the scenarios you talked about. And then in that situation, it doesn't form the definition of an intimate image if that reasonable expectation of privacy didn't exist at the time that it was taken, right? We do have provisions in here that talk about whether or not there was a reasonable expectation of privacy, but there was consent. So the person had consented at the time under that circumstance for distribution, but they revoke that consent and then they're able to pursue a claim because consent can change at any time.
Member.
Well, I think the attorney has answered the question in a way that makes sense to me. There is that distinction where there is not a reasonable expectation of privacy at the time, that is not something that can be cured later. The definition of intimate image has not been satisfied. Therefore, in the second example, the definition has been satisfied, consent has been granted, but then later revoked as provided. I think the attorney has helpfully drawn the distinction. That's it for clause 1, Madam Chair.
Shall clause 1 pass? Aye. So ordered. Shall clause 2 pass? Aye. Member.
The part of clause 2 that I just wanted to spend a moment canvassing with the attorney is 2 sub B sub 2, which read in its entirety, and again it comes back to this notion of reasonable expectation of privacy. A reasonable expectation of privacy in an intimate image is not lost only by reason of consent of the individual to the image's distribution by a person other than the individual at the time and to the extent of that consent. And I want to make sure I understand that. Is that to say that if an image, coming back to the point the attorney made a few moments ago, if an image, if there's a reasonable expectation of privacy, you never lose that. You are always entitled to that reasonable expectation of privacy, though you can consent in perpetuity or for a particular purpose or for a particular period of time to have that image distributed. It has not lost its character as an image for which there is a reasonable expectation of privacy. Am I understanding that provision correctly?
Minister.
Yeah, so basically, as the member I think was getting to, it establishes that the reasonable expectation of privacy in an intimate image is not lost just because the image is consented to one person. So you can say that, for example, a person consented to the distribution to another person, but that does not entitle that person to distribute it to 2 other or 3 other. And so it'll be up to the decision maker in the scenarios to decide the extent of the consent. And if it's withdrawn, then that's also covered in the Act. So.
Shall Clause 2 pass? So ordered. Shall Clause 3 pass? Member.
Thank you, Madam Chair. I draw the attorney's attention to Clause 3, Sub 2, Sub B. It just might be helpful to put on the record an example where an intimate image can be lawfully distributed without the consent of an individual.
Minister.
So one example for that subclause is to capture things like a police investigation.
Member.
Thanks, Honourable Chair. Right, so an investigation that for which there was evidentiary significance to an intimate image as defined in the Act, nude or nearly nude, engaging in a sexual act, exposing genital organs. So advancing the purpose of an investigation and then sub A of that same subsection 2 speaks of the it being impractical in the circumstances to obtain consent. Does that relate? It doesn't seem to relate exclusively to law enforcement court proceedings or investigations. It seems to contemplate other circumstances in which it might be impractical to obtain consent. What would an example of that be?
Recognizing the member for Vancouver-Langara.
Thank you, Madam Chair. I wish to seek leave to make an introduction.
Is leave granted?
Thank you, Madam Chair. I mentioned before question period that today we have visiting in the precinct and the Assembly 3 groups from Eric Hamber Secondary School in my riding of Vancouver-Langara. I met with the second group on the back stairs in the education entrance and had Minister for Mental Health and Addiction Recovery come by and say hi, as well as the member for Vancouver, West Vancouver Capilano. Ms. Lemon is here as the teacher with about 25 grade 9 and 11 students from Eric Hamber Secondary, as I mentioned, the school that my wife and her siblings, as well as my nephews, have gone to school at. I talked to them about my Youth Advisory Council, my youth forum this coming Saturday. I hope that they can join at the Sunset Community Centre from 11:30 to 2. We are in process here with my good colleague, the member from Abbotsford West, debating with the Attorney General an important bill, as I mentioned to the first group coming through, about legislation to ensure that people like yourselves are safe from intimate images being circulated on social media. It's an issue, of course, not just in terms of for young people, but in terms of cyberbullying and other aspects of exploitation. We need to ensure that people like yourself are protected. And so this is the back and forth committee review, section by section, of that very important bill. I hope you enjoy the rest of your tour. And the member from Peace River North is now waving at you as well. Thanks again.
Minister.
Thank you. So really, I start by rooting it in the purpose of it. So the purpose of this is to not impede a matter that's in the public interest in terms of you always are trying to seek consent, but if it's impractical to seek it and it's impeding something, then of course that we carved out a provisions of that. For example, if the accused is in one of the images, or it's a rushed matter, or there's certain scenarios that may come up in a police investigation that make it so it's impractical.
Member.
Right, I'll try one more time, because 2 sub B seems to embrace everything and anything one can contemplate involving a police investigation or a investigation, a court proceeding, law enforcement. Sub A seems to contemplate, and the language is, it's impracticable. The law enforcement investigation, court proceedings, investigations, they have their own exemption. I'm just wondering if the attorney and the government were contemplating something beyond those kinds of investigations where a circumstance would occur where it's just not practicable, and that would justify dispensing with consent.
Minister.
Yeah, thanks. So I'll start by saying again that the idea behind the Act is to seek consent, try to seek consent if possible. And the scenarios that we've carved out in terms of being impractical to seek consent, as I mentioned before, it could be things like somebody's under investigation and they're depicted in a video, and it's in the matter of that interest that there's an exception carved out to that consent. It would be hard to think of every scenario that might come up with, but I guess the intent there is to make sure that the purposeful use of the image or the distribution of the image that's not meant except for these scenarios is protected.
Member.
Okay, thanks, Honourable Chair. I'm going to move on and leave it with this observation that my experience with the drafting of these things is in a case like this, where on the one hand in sub B there is a very specific exemption created, and it relates to law enforcement investigations and court proceedings. That's one thing. And then the drafters, and presumably on the instruction of someone, have contemplated that there might be something else, because I think the examples the attorney gave would all be captured by sub B, the 3 cases in sub B, that someone has contemplated that there might be something, there is something beyond these investigations that would justify dispensing with consent. And if I could think of something, I would offer it up, but I can't think of anything, and that's why I'm asking the attorney.
Minister.
So it's hard to go scenario by scenario of what might fit into this, but I can give another example. So if it's Crown deciding to lay a charge on somebody, right, it's incidental to an investigation, it may be distributed, but it's captured under this if it's impractical to get the person's consent.
Shall Clause 3 pass? Aye. So ordered. Shall Clause 4 pass? Member.
Thanks, Honourable Chair. So here's where we come to the important concept of revocable consent. So a scenario in which an intimate image has been captured, consent has presumably been given to allow for distribution, and then the person depicted in that intimate image has had a change of mind and says, I am withdrawing that consent. And that requires a response and certain behavior from the person to whom that consent has been revoked. So the first thing I think I'd like to ask, and again, this is one of those questions that could be asked in Clause 4 or 5, either one, and I promise I won't repeat it in Clause 5. So in a situation where intimate image has been captured, consent has been given to distribute it, and the individual depicted in the intimate image subsequently has a change of mind and withdraws the consent, in a case where they have brought or are intending to bring an application under Clause 5, can that application be considered prior to the revocation of consent? Is it, in order to bring that application, must the applicant demonstrate to the adjudicator, yes, I initially gave consent, but I have now withdrawn that consent, and here is the evidence of that?
Minister.
I'm just, if I could please ask the member to clarify the question with more specifics, I think it would help us.
Member.
All right, let me, I think the easiest way to do this is by way of example. So we have an applicant seeking to avail themselves of the relief available under Clause 5, some injunctive relief for a takedown order. I think my question is this: are they able to, in a scenario where the applicant who is captured in the intimate image, so we have an intimate image, the applicant has been captured in that intimate image, but has initially provided consent for its distribution, now has a change of mind for whatever reason, in order to successfully advance their application under Clause 5, must they first demonstrate that they have availed them, have revoked that consent? Is that a prerequisite to securing relief under Clause 5?
Attorney.
Okay, so I guess it starts off by saying we do have a process under Section 4 of revoking consent, and it involves communicating with the person. Clearly, an act of filing an application is also saying that the consent is withdrawn, and there may be circumstances where it's very not possible to communicate that that there was no consent. For example, if it was taken, we mentioned earlier about the technology that can take pictures of somebody without them knowing up their skirt or something and then distribute it, right? You're not going to be able to go find that person and say, you know, I don't consent to that. So we have to keep in mind those scenarios when we're thinking about it. But clearly, the clearer way also is making an application that consent is no longer available, but also there is a provision under 4 that talks about the process of revoking consent.
Member.
Right, and again, I don't want to belabor this, but I think what I'm trying to establish is that in cases where consent has initially been given, absent a circumstance in which it is not reasonably possible to revoke that consent as per the provisions of the Act. But in a situation where a person does have the means to revoke that consent and communicate it, it strikes me that it would be reasonable for a tribunal to say, and for us to say, that prior to seeking tribunal relief and injunctive relief, communicating that revocation of consent would be a prerequisite. And is that how the Act is intended to operate?
Attorney.
I just want to start by, I think, maybe bringing some clarity about how this fits into the Act, this provision. So first of all, by saying that Section 4, its main purpose is to make it clear that consent is revocable. So you can have a process where you consented and then no longer. And that actually brings a very important level of clarity to that idea of consent. But bringing an action or an application under this process does not require you to have contacted that person and said, you no longer have my consent. There are legal tests within the process where you can determine and the respondent can make claims about whether consent was available or around, and that's a legal determination. But I think the basic point of that provision is to make it clear that it can be withdrawn, but then also you have to guard in the process against scenarios where there may be a safety concern about notifying the person who distributed the image. There may be a power imbalance, there may be violence, there may be tons of reasons where you would never require the person that is the victim of this type of non-consensual disclosure, or in this scenario, the applicant, to have undergone a process of saying, hey, you no longer have my consent. So I think I just wanted to clarify that in terms of the way this fits into the Act.
Member.
Right, and fair enough. I think that is helpful. And I'm going to add this scenario from a slightly different perspective, and that is let's try to take maybe a realistic example of the relationship that has been in place for a number of years. The parties have captured intimate images of one another and consensually placed them on one of these internet, I forget the term, but internet intermediaries, I think is the term. Life is good, and there was a breakdown in the relationship, and the parties separate, part company, and deal with it maturely, and are on their way, and then suddenly one of the parties finds themselves on the receiving end of an application, or discovers that an application has been made under Clause 5, or becomes a respondent under Clause 6. And what I'm going to suggest, and the claimant says, well, I now withdraw revoke my consent. Yes, there was consent, but I've decided to revoke it. Well, did you ever tell the other party? No, but I am now because I've commenced this action. I'm going to suggest that there can be a stigma attached to the respondent in that case, who in that scenario hasn't necessarily done anything particularly bad. So yes, I agree. There may be circumstances in which the ability to communicate revocation of consent is compromised and not practicable. But I can think of other circumstances where it would be fairly reasonable to expect that before seeking relief, communicating that revocation, informing the other party the consent that I have given is now at an end, and please take the steps necessary to respect that.
Attorney.
Just some clarity from the member if there's a question there or something that specifically you want me to respond to with respect to that.
Member.
In the example that the attorney gave, I think she made a partial case for why it shouldn't be necessary in certain instances for a claimant or an applicant to demonstrate that they have revoked consent. I have tried to make the case through a different example for why in other instances it would be eminently reasonable to require a claimant to demonstrate that they have communicated a revocation of their consent. A, does she agree? And B, how does she believe the Act would operate to address that?
Attorney.
So the rest of the Act and the point of it is to stop distribution. So it would be available to the applicant, just like all of our justice system, for them to seek remedy in the forum that they feel is the most appropriate for their issue. So if in the example there, if a partner does, on the ending of a marriage, does want an order to stop the harm of distribution, then of course it's open to them to do that. And we'll go later on, I think, when we get to those sections about protections that are available to respondents in the process.
Member.
All right, if we can stick with our the rough example that I gave, let's take a case where revocation of consent has actually been communicated to the other party, to the person who distributed the intimate image. Then 4 sub 2 sub C becomes relevant. The individual depicted in the intimate image, has communicated that revocation to a person who distributed the intimate image. The person who distributed the intimate image must make every reasonable effort to make an intimate image unavailable to others. What's the attorney's view of what constitutes reasonable steps? And by that I mean, an image has been posted and on one of the internet intermediary platforms that we talked about earlier. I suppose it's a fairly straightforward thing to say on the person who's initially distributed, they take it down off their Facebook site, for example. Except in the intervening 2 months, the thing has distributed very, very widely through whatever those internet networks that people have via Facebook channels. How far does that obligation extend in terms of, one can contemplate circumstances in which simply taking it down from, let's call them the host's Facebook site, is not going to make that image disappear from the internet. What is the nature of the obligation that an individual has who has at one time distributed an intimate image with consent and is then told, I am withdrawing that consent?
Attorney General.
Thank you, Mr. Speaker. So like many things in the law, the reasonable standard is applied to the facts, and the facts will vary greatly. And so, for example, if there was consent to put something up on one website, right, and then it was distributed widely, then a decision maker may look at those facts and say, in this scenario, what's reasonable is for the person to take it down from that website, and they may not be as liable for the rest of the distribution, for example, right? And it's going to weigh depending on the facts of the scenario in front of them. Whereas, if there was no consent and it was posted, then obviously the decision maker is going to have probably a broader scope of accountability for that distributor. So it'll depend basically on the facts of the case, what the reasonable standard is.
Member.
Thanks, Honourable Chair. Well, let's explore that a little bit further, because I think this might become a fairly regular, well, hopefully not too regular, but a fairly normal type of transaction. So again, using the example, relationship breaks down, the image that has been posted with consent and therefore distributed with consent, the consent is withdrawn. In the attorney's mind, we'll call the person the distributor, takes the image down from his or her site, Facebook site. Does that person, to the attorney's mind, acquire an obligation to go further than that and notify the host platform, the internet intermediary, that I have received revocation of consent to post this, I have taken it down, and I ask that you do so similarly elsewhere on your platform?
Attorney.
Thank you. That's very likely an order that a tribunal or a court could make with the individual, that is the obligation that is on them to notify the company and take down. It would be up to the decision maker in that scenario, and I'm sure it will depend on the facts and the reasonableness and the actions to mitigate that are reasonable in this scenario.
Member.
Right. I don't think I've communicated this very effectively, because the premise of my example is that these are two people who are trying to manage through a breakdown in a relationship and do things responsibly, and quite frankly don't want to make an application and don't want to be the subject of an application, want to do this correctly. And so how far does that obligation go on the part of the former distributor, who has now complied by taking down the intimate image on their site, but knows full well that 40 of his or her friends has got the image, and that it exists elsewhere on that platform, and doesn't want to wants to do what is reasonable to comply with the law.
Minister.
Thank you, Mr. Speaker. So I'll start again by saying that the Section 4 is really there to make it clear that consent can be revoked, right? And if the parties have communicated and done those steps, it may be that there is no application, as the member suggested, that the reasonable steps were taken, and so there is no application before a tribunal or a court. The Act as a whole does give guidance on what reasonable is. So if you look at subsection 5, I'm sure we'll get to it, it talks about some of the efforts that a person could take that would set a reasonableness standard, but of course, it's going to be factor and fact-based. So I think as we have this in place over a period of time, there will be increasing decisions and an idea of what the standards as they develop are in the jurisprudence.
Member for Abbotsford West.
Thanks, Honourable Chair. Couldn't help but observe that there's a fair number of younger people in the gallery who probably had no idea debates in this chamber were so exciting. And yet, ironically, the provisions, the legal provisions we're talking about are probably more applicable to them than any other segment of our society, and a testament in many ways to how technology has both simplified but also made our lives far more complicated, and there's a whole broad range of legal responsibilities that go with how we utilize that technology properly. Well, let's go to Clause 5.
Thank you, members. Shall Clause 4 pass? Aye. So ordered. On to Clause 5, Member for Abbotsford West.
Thanks, Honourable Chair. One of the things that the attorney, I believe, has tried to emphasize throughout this discussion is about how this is there's a victim-driven component to how the Act was put together, and that lens has been prevalent, and providing, in the case of Clause 5, speedy access to redress and in lawyers say injunctive relief, but everyone else would say getting the image out of the public domain. And that's sort of the heart and soul of what Clause 5 is about, as one of the two avenues for remedy and relief. So what I'm interested in giving the attorney an opportunity to do in a fairly detailed way is explain how she sees the procedure for this. And I hope we can maybe collectively paint a bit of a picture of the 18 or 19-year-old young lady who has discovered that an intimate image of her is inhabiting the internet without her consent, even if she knows who the source of that distribution is. She may not know how to contact them, want to contact them, is just aware that it's out there and wants it off the air. What is she going to do? And I understand that when we're talking about procedure, the minister can simply say, well, all of that needs to be worked out, the tribunal. But maybe what I'm asking the attorney to take advantage of is to lay it on the record what she expects and hopes and challenges these tribunals and administrators to create, and how she sees this as working effectively.
Attorney.
Thank you, Mr. Speaker. As the member noted, there's still work to do on implementation, but I'm happy to say this is an area that we've given a lot of thought to. And I think it is valuable, and I thanks for the opportunity to put on the record about the thinking about what the process will be like for a young person, as you mentioned, if they come forward. So the victim will start with this, we'll just say the CRT process. So how do you get an order from the Civil Resolution Tribunal? The process will start with the victim encountering a solution explorer. And the Solution Explorer is an artificially intelligent guided pathway. So it's designed specifically for this type of issue. It will help the victim diagnose the problem, provide information, provide self-help steps, off-ramps, and other services and supports. And the supports are really important because we know oftentimes they're very vulnerable in this situation and can have trauma and other mental health issues associated with that. And information on the streams for the application process. So the self-help tool, we think, will offer a fast and easy way to address the intimate images. So this is a tool that's available 24/7. You can access it will be able to access it on your cell phone, and it'll guide you through the steps of giving notice to the wrongdoer or the internet intermediary, confirming the absence of consent to distribution, and that an application may be made under this statute once it's passed. If it is passed, with the potential to result in damages and penalties to the wrongdoer. So if the victim proceeds as an applicant for an expedited intimate images protection order, the CRT will then screen the application to ensure it's no missing information, it's within their jurisdiction to do so. And it also provides the opportunity to see if the applicant reports any special needs or limitations that require just additional support. So, for example, if there's visual impairment or other things that require special tools. Next, there's a specially trained CRT case manager that will work with the applicant to explain the timelines and the steps and to ensure that the information is available and it's ready to go for a quick and focused adjudication. If there is a respondent, I'm sure we'll get to that process at some point, to the applicant, the case manager may do the same steps with that party. And then finally, the trauma-informed tribunal member will review the application and make a determinations on orders that they deem appropriate. Oh, I have more here that I'll just go through just to put it all out there. So the victim then can provide copies of the determinations or orders to the individuals or intermediaries as required to prevent the distribution. And then if an order from the CRT has been contravened, the tribunal may decide to order the contravening party to pay administrative monetary penalties after these people obviously have had a chance to be heard. Yeah, and the option will be there to file and enforce orders with the Supreme Court if necessary.
Member.
Thanks. Okay, that's a good start. It gives us something to work with. Let's try to break that down a little bit in terms of what that looks like from the point of view of the 18-year-old young lady. So I took from the attorney's comments there will be an online self-help mechanism that young people are pretty adept at navigating in most cases. The attorney then referred, and I'm not trying to, again, be mischievous or trip up the attorney, but I thought in that sequence, she also referred to notifying, and this was prior to talking about obtaining an order. She talked about notifying the internet intermediary and or the distributor, which left me with the impression that whoever is developing this procedure, and I'll draw an analogy. The last time someone hacked into my credit card and I called MasterCard to tell them, or there was a disputed transaction, the first thing they said to me was, well, before we can do anything, you have to approach that vendor. And what I thought I heard was a reference by the attorney that prior to obtaining it, there is going to be some obligation on the part of the applicant to contact the internet intermediary or the distributor.
Attorney.
Just to clarify, it's not a bar and it's not a requirement. It's just an option for the party at that stage. They will be given information about the process, and one of the options is to do that. But obviously, they're entering the process likely to get a chance to get a legal order, right, for the protections that they seek.
Member.
Thanks, Honourable Chair. The whole exercise, I take it, with the CRT is intended to be take place online. Is there a hearing component, albeit a virtual one, but a visual hearing component to the application, where, to use our example, the 18-year-old applicant is speaking to someone virtually over the internet to explain the nature of the issue and the relief she is seeking?
Attorney.
So the CRT is designed in our system to be a low barrier multi-channel process. So it can be up to a hearing. It can be document driven, so just a document driven process. There can be other ways for the tribunal member to answer questions. So I think it really is driven by probably the complexity of the matter. And the determination of that tribunal member of what's needed. So yeah, there's many options when it comes to resolution, up to an online platform or online tools that are available.
Member.
Thanks, Honourable Chair. Would the attorney agree with me, though, that what distinguishes this particular type of action under Clause 5 is, one, it generally will not involve another party. My sense is that unlike Clause 6, the provisions are designed, lawyers would say, to facilitate an ex parte applique, that is, the other party, there is no other party. That's the first thing. And then the second thing is speed. And so when we start hearing descriptions of various possible channels, and the other term for that is time, more time, as people decide what, I actually thought what the attorney was going to offer as an objective in this was that when the 18-year-old girl submits the application, that the next day there was going to be a hearing in front of a live person that said, yeah, here's the order, or here's not the order. Because everything else starts to sound like we're measuring in days and weeks, which I would have thought defeats the purpose here.
Attorney.
Yeah, so my response to the last question was directly related to the question which I thought was posed from the member, which is about the ways the hearings can be obtained. But the answer about how the speed of the process is it's very much this is designed to be a fast process. So, for example, a real-time hearing is oftentimes takes a while, right? Because you have to schedule and do things like that. So you could do something as much as online submit your documents, and the tribunal member can have enough information just based on that, right, to issue an order, which could be pretty quick. If there is a visual impairment, you might need a phone call with the tribunal member. But the idea is very much to do orders quickly. So.
Member.
Thanks, Honourable Chair. Is the attorney prepared to set out for the committee her and the government's objective as to a response time for an application? Again, in the example I'm using, the 18-year-old girl who discovers an intimate image is on the internet, or she has been threatened that it will be placed on the internet. Is the attorney prepared on behalf of the government to say our objective is to ensure that that application, once submitted, is heard and ruled upon within X number of hours or X number of days?
Attorney.
Thank you. So obviously implementation details are going to be worked out with the Civil Resolution Tribunal, but I can assure the member and the public that timeliness will be a key factor when it comes to the rollout and design of this process. And the intention of, for example, the Solutions Explorers, for that to be something that's available 24 hours a day, 7 days a week for people to look through. So yeah, timeliness is a key component of how we plan to roll this out with the CRT.
Member.
Right. Thanks, Honourable Chair. I get it. Governments don't like to be pinned down on time frames, but the whole point here. So if you're a lawyer in downtown Vancouver and have all of that training, all of that background, if you decide you got a client that's prepared to pay enough money, you can get into court the next day and get an ex-parte order. Now, that's not what we're dealing with here. We're dealing with a different group of people who don't have that expertise and constructing a system that is intended, and I accept is fully intended to accommodate that. All I'll say to the attorney is, if governments don't lay down in a very public way what their expectations are, they're destined to be disappointed. And it won't happen in a timely way, despite everyone's best intentions. So I think, and I now will put words in the attorney's mouth, which I shouldn't do, I think what the attorney is looking for is a system that is easily navigated by that 18-year-old young lady, that when she gets online and submits the application, assuming it is complete, that she can get an order the next day. I mean, I think that's what the attorney would like to see, and why she is commending this legislation. And if that's what the attorney and government would like to say, then say it. I understand that the attorney doesn't sit in the civil tribunal office, but I think they need to know what the expectations of the House are, but quite frankly, more importantly, what the expectations of the the Attorney General are. And yes, there's a risk. There's a risk it won't happen, and then guys like me will come along and give the attorney hell for not having hit the objectives. But if we don't tell them what our expectation is, then I can guarantee you it won't be hit. And it'll be another process that is fraught with delays and doesn't accomplish the objective. So that's my attempt to prompt the attorney not to be shy about telling the House and by extension others what her expectations are and what her hope and objective is for the speed with which this process is undertaken.
Attorney.
Thank you, Mr. Speaker. I think I have been clear in setting out my expectations for this process. I've said clearly that we want to, and what's in the legislation is a timely and victim-driven process that provides many protections for the victim. The goal is to have the orders and the access to justice, not only low barrier, like the 24/7 Solutions Navigator, but also the process to be low barrier and expedited. I'll be working with the Civil Resolution Tribunal over the next, me and my team, over the next few months to have this process set up, and the expectations, I think, are clear about timeliness. Thank you.
Member.
Oh, okay, thanks, Honourable Chair. There's a fine line between clear and vague, and I won't try to bridge that today. I think I understand, I accept that the attorney wants this done in a certain way and hopes that 18-year-old young lady can get a quick response. I would urge her to be very specific, and if she's not prepared to do so publicly, then do so privately with these panels to ensure they understand what her and the House's expectations are. Just a couple more questions then about the application process itself. I presume, but the attorney can confirm this, that the body of material that an applicant would have to submit will include the intimate image itself.
Attorney.
Thank you, Mr. Speaker. So the applicant must show to a tribunal member that the image is an intimate image depicting the applicant, right? That's the legal wording of what they have to show. So, I mean, in many scenarios, it'll probably involve the image, but you can imagine some scenarios we have protections sometimes where a written depiction, a written description of the image is less harmful to the person, but may be sufficient for the tribunal member to give the order. So I don't want to say that in every situation that would involve the image, but just to say that the legal test is that the image, the decision maker has to be satisfied that the image depicts the applicant.
Member for Abbotsford West.
Thanks, Honourable Chair. There's going to be, maybe I should ask the question this way. To facilitate the ease of access, there is going to be a checklist of things, name, contact details that an applicant needs to include to initiate this ex parte application before the CRT or one of the other tribunals, but we've focused on the CRT for these purposes. And to guide the applicant, there's going to be a checklist. I'm suggesting that even though there may be exceptional circumstances where the tribunal can't see the image or maybe the applicant doesn't have access to the image, but but in general, there would be a box that says the tribunal who is ruling on this matter needs to see the image. And the reason I ask that, and the minister may be thinking the same thing even that step may be traumatic for an applicant, and yet that notwithstanding, it would seem to me that it will be a necessary step in most cases for the tribunal to render a decision.
Attorney.
Thank you. So we're still working out the details, and it'll be probably by regulation that a lot of that, or process with the CRT, that a lot of that shows up that the member was talking about. But I mean, it's reasonable and likely that that will be part of the process. But you could also think of scenarios where you just send a link, right, to the website rather than the image. There's other ways to maybe fulfill that, the evidence for that legal standard. So.
Member. Right, and that's a fair point. And coming back to what the attorney said earlier, in rendering its decision whether the image is provided by the applicant or it is the tribunal secures access to it by a different channel, in virtually every case, it is going, in rendering a ruling, it is going to need to see the image, and I think that's my point, and it sounds like the attorney agrees with that.
Attorney.
It's quite possible and likely, but I want to say that I don't want to foreclose any other potential ways of meeting the legal standard out there that may be less harmful to the applicant, so that we may come up with regulation in the process.
Member.
Thanks, Honourable Chair. All right, well, I'm sufficiently to at least ask having said that, what might that be? What might those, in a case where a tribunal is being asked to make a ruling about an image, what alternatives might exist that would preclude the need for the tribunal to see the image?
Member Vancouver Langara.
Thank you, Mr. Chair. I seek leave to make an introduction.
Is leave granted? Please proceed, member.
Thank you, Mr. Chair. This is the third group from Eric Hamber Secondary School that I'd like to welcome to this chamber. I had the further opportunity to welcome them on the back steps with the member from Abbotsford South who tried to misdirect them, but you're getting waves there from the government members. I must say, I didn't say this on the back steps, but I'll say it now, that it does give me some bittersweet sense to be in this chamber and with this school group, because this is my last introduction for Eric Hamber Secondary School in this chamber prior to the tabling of what we expect to be the Electoral Boundaries Commission final report, at which point Eric Hamber Secondary School will no longer be technically in the riding which I represent for the last 6 years for Vancouver Langara. But many families, of course, and students will still live in my constituency, and I look forward to that, but I won't have probably the technical ability to make this introduction. So I hope you enjoy the balance of this debate on Bill 12, Intimate Images. The member from Abbotsford West, the Shadow Minister for Justice, is quizzing in detail, section by section, a very important bill to protect people from the circulation of intimate images. We know that that has been a concern, including amongst young people, and some unfortunate incidents causing a lot of harm to people, including in a cyberbullying way and other exploitation type ways. So the Attorney General and her team are conferring, and they'll be addressing the response to my colleague, the member from Abbotsford West. I hope you have a good rest of your tour and that you'll consider attending my youth forum on Saturday, April 1st from 11:30 to 2 at Sunset Community Centre. I've given that information to your teacher, and also consider my Youth Advisory Council as well. Enjoy the rest of your tour. Thanks very much.
Thank you, member. And go Griffins, I think that's the team. Yeah. Attorney General.
Okay, I believe I mostly answered the question, but just to bring further clarity to that, there are examples in provincial court in family law where there's a particularly sensitive or vulnerable, very young child, where there are incidents of intimate images where they've done things or processes like ask for affidavit evidence describing the images, and then in that case the judge would determine whether or not it's necessary to disclose the actual image or not. So this is just an example of a protection where there's a building up of evidentiary basis for describing an image rather than entering it. So that was the reason that I said likely that the member is right, the image will be a part of the determination, but there may be scenarios, especially with very young children and images of that the tribunal or the court may want to protect the child from disclosure.
Member.
Okay, and I accept that. I mean, I think that's a reasonable response. The only reason I brought it up is I think we should be upfront with about the fact that for the vast majority of applicants beyond a certain age, there is going to be an expectation that they share with the tribunal the image or images that, or at least an image that is causing them distress or they've been threatened with posting. So we'll leave. I'm satisfied with the response the attorney has given on that point. Further on in clause 5, when we get into subsection 2, and sub C starts to talk about some of the authorities that the decision maker has. Our example has been with the CRT, so let's stick with that just for the ease of our conversation here today. in sub C, it contemplates an order for an internet intermediary or other person or organization to do certain things, including removing intimate images from the platform and that sort of thing. But to be clear, there's no requirement, and it's really there's no requirement, and dare I say no expectation that the internet intermediary would be a party or even receive notice of this application.
Minister.
That's right.
Member.
I'm sorry, just going to jump ahead again with the pledge not to repeat the question. Is that different than the next section in a situation where a claim for damages might be made? Is there a distinction between clauses 5 and 6 with respect to the need to notify an internet intermediary?
Minister.
Okay, thank you, Madam Chair. So maybe I'll explain it in relation to both of those provisions, just to help bring some clarity to it. So the first thing is that Section 5 is all about stopping the harm, so reducing, taking down the images, getting the orders necessary to prevent further distribution. So in that situation, there's no naming or notice for this example raised by the member of the internet intermediary. When it goes to the damage section, so to claim damages, that's more of a claim, just like a civil claim for damages. And in that case, there are notice requirements. And likely, somebody could pursue damages against an internet intermediary in that scenario.
Member.
Still in, thank you, Madam Chair, and to the attorney. Still in 5 sub 2 sub C, there is a description of the orders that the decision maker can provide, and that is removing the intimate image, deleting or destroying the intimate image, something called de-indexing, which the minister's staff kindly informed me relates to the non-retrievability as part of a search. So I'm obliged to them for explaining that to me earlier. So the question, of course, that emerges from that relates to the enforceability of the order that is achieved from the decision maker, the tribunal, or the courts. Here's what the Uniform Law Conference had to say about that. It's not lengthy, so I'll just read it into the record. A court order under Section 4 in their act, I believe they were referring to what is now our Clause 5, will allow an applicant or respondent, depending on the order, to seek takedown or de-indexing of the content directly from the internet intermediaries hosting the content by sending the order to counsel at the intermediary's corporate office. Most internet intermediaries prohibit users from posting unlawful content Therefore, a court order under Section 4 or Clause 5 will serve as compelling evidence that the intermediary's terms of service have been breached. There's then reference to some Supreme Court jurisprudence. And then this observation, in the working group's opinion, most internet intermediaries are likely to comply with takedown or de-indexing orders issued under the Act. As a matter of practice, most major intermediaries comply with local law. Therefore, there is no reason to believe that these companies will resist content removal. I guess the question that one is obliged to ask is, does the attorney share the working group's optimism about the willingness of internet intermediaries located outside of this jurisdiction, outside of our provincial jurisdiction, outside of Canada, to honor the orders that emerge from within BC?
Minister.
Thank you. I want to thank the member for the question. I think it's a really important one because we're existing in British Columbia in an international issue, right? That a lot of these issues or claims have no borders when it comes to their impact, but also the companies that operate. The reason I do share the optimism of the clause that the member read is for a few reasons. So first and foremost is the activism and the advocacy of people like Carol Todd, who have organized on an international level to bring attention to the harms related to this issue, and specific websites that have been established on an international level that one called, I believe it's Take It Down, that assists with survivors of this type of sexual violence to get things taken down. And also a lot of the larger websites and companies are trying to address this type of harm. What we're doing with this legislation is sharpening our tools in this province to protect people and to set out pretty clearly what is unlawful conduct in our province when it comes to distributing these images. And by setting that clear standard and setting up a process to go to these internet intermediaries and say, to say this is unlawful distribution needs to be taken down, I am optimistic, and I do believe that that will have the intended consequence of having that stuff taken down.
Member.
Thanks, and thanks to the attorney. The working group, as part of their optimism, referred to the ability to send notice of orders to the internet providers, internet intermediaries, corporate offices. Do agencies like Facebook and Twitter have corporate offices in British Columbia?
Minister.
Thanks for the question. So I don't know where all of the offices are located for the probably many internet intermediaries that may be an issue may be delivered to them under this process. But what I would say is that if there is a BC office, it's obviously a clearer delivery. But that being said, once an order is made, an attempt to reach them in every possible way. So whether there's a Canadian office or an online way to contact them or other offices to issue the order, I think would be necessary.
Member.
Thanks, Honourable Chair. Maybe another way to ask the question, recognizing the international dimension to this, is we have these platforms I mentioned too, and the attorney has mentioned the same ones that I believe are ultimately headquartered in, well, let us say, common law jurisdictions. I think in both those cases in the U.S., ultimate corporate headquarters are in the U.S., but in a common law jurisdiction. Is the attorney at all concerned that the enforceability of the orders that might derive from this legislation become more difficult in cases, in the case of platforms that may exist, and I don't know what they are, although I'm told they exist, platforms, internet intermediaries that are based in non-common law jurisdictions or parts of the world where the rule of law may operate in a significantly different way than we might appreciate here.
Minister.
Yeah, I just want to thank the member for this really important question. And I know as someone who practices law, you also, or the member is aware of the complications with international enforcement, and I think brings up a good point about how to enforce against countries that may not have the same kind of legal protections or common law as we do. And so I think there's a few important provisions in this that at least strengthen the ability or the position of the applicant. And so one is monetary penalties, but also access to the enforcement mechanisms of the BC Supreme Court when it comes to enforcing their orders. So we can't be certain that the legislation will be effective against every foreign actor, but it will give survivors more tool to address them and better options when it comes to seeking them out. And I think this is certainly certainly something that we're happy to do for survivors is give them better options and better tools, including access to the BC Supreme Court to enforce orders that are made under this.
Member.
Thanks, valid and important points that the attorney has made, but I guess we have to follow the line of questioning through to its logical conclusion. The 18-year-old young lady has secured an order from the tribunal to take down a intimate image that has been posted without her consent. She avails herself further of the rules that allow that to be registered as an order of the Supreme Court of British Columbia, and the internationally based internet intermediary, and I won't name one because I don't think that would be fair, says, yeah, that's great, and ignores it. Anything that can be done, anything that that person can do in those circumstances?
Minister.
Thank you, Madam Chair. I think it is difficult in those scenarios, the one that you've identified. The position that we've taken with this legislation and even the act of stepping forward to create a new system of justice for people in this scenario is to do what we can within our legal tools and to strengthen our justice system. So as I mentioned before, these orders would give access to monetary penalties and also the processes in the Supreme Court that we have for enforcing orders. And I think those are ways that we thought and we knew that we could strengthen the tools available to survivors, but there are scenarios that are very difficult.
Member.
Well, notwithstanding the challenges, I think that is a wonderfully honest response. And thank you, because I think it's important for people to know that as we create these avenues within British Columbia, our jurisdiction is limited. We don't need to do, but happily we have reciprocal enforcement agreements with many countries, so there are some avenues, but for those internet providers that may seek to hide out in jurisdictions that don't have the same sense of responsibility or respect for the rule of law, it will ultimately be difficult. And enforcing orders even in other jurisdictions with whom we have those agreements is a challenging task as well. But I appreciate the attorney recognizing that for all of the sound intentions, there are some limits that extend beyond what this place and this jurisdiction can accommodate. and address. Limitation periods, and there are some different provisions as it relates to monetary penalties, but for Clause 5 and the pursuing an order and relief under Clause 5, how does the limitation provisions apply? And I hope the attorney has very capable and informed staff, but I hope she'll go beyond saying the usual limitation periods apply. What I'm really looking for is, again, going back to our example, is there a limitation period for that 18-year-old young lady who has discovered this intimate image that has been posted without her consent? Is there a limitation period within which she must seek redress under this provision?
Minister.
Okay, so I'm going to start my answer by saying the Regular Limitation Act in BC will apply, but I'll give some more details when it comes to that. So under that regime, when you think about how it might apply to these scenarios, first of all, I'll start by the exceptions that are under the Limitations Act, particularly for minors. So all of those exceptions would apply. The next one is discoverability. So in the scenario where the person hasn't discovered that it was out there, of course, she'd be captured by those protections under the Limitations Act. And then the other principle under Limitations Act that may be implicated in the facts is continuing fact, right? Like, so the fact that the image is still up there for maybe let's say 5 years, right? It's still an ongoing harm and ongoing basically breach to that victim. So then that would also be protected under the Limitations Act. So it would extend potentially the period for limitations.
Member.
Okay, thanks. That's so that's helpful. Discoverability. We'll come back to our example. 18-year-old young lady finds out that this intimate image has been posted. If it's taken down, I suppose she could still seek injunctive relief to make sure it's not reposted, but the likelihood of her doing so begins to diminish if it's outside of the public domain. But in that case, is it 1 year that she would have to seek that? And now we're talking about under clause 5, from that she has discovered it, it is taken down. She has 1 year or 2 years to seek relief under clause 5.
Minister.
So I just to start maybe with a head nod that you were talking about a claim under section 6 in damages. Section 5. So maybe then I need a question of clarity to the member. So are you saying after, in the scenario you've given us, you've said the image has been taken down. So maybe I need clarity to understand which order the person would be seeking under section 5.
Member.
Thanks, Honourable Chair. Right. 18-year-old discovers image, intimate image has been posted without her consent. It then comes down. I've acknowledged that the likelihood of her seeking an order under clause 5 diminishes, but it is still conceivable that she would seek injunctive relief, plus the possibility of a threat that it might be reposted. But even that's not a great example, because I presume the limitation would run from the moment the threat is made. But I'm trying to establish the difference between a case where the images come down and she might want injunctive relief to protect against its reposting, versus a case where the image is still there, in which case I take it, as long as the image is up, she maintains the ability to seek relief under clause 5. As long as the image is up, she falls within the limitation period.
Minister.
Okay, I'm giving a lot of disclaimers on this answer because it depends on whether or not there are other sections of the Limitations Act that the person might be able to avail themselves out of in the very complicated scenarios that people have. But I would say, barring any other exception, right, the limitations would start the minute the image is taken down. Yeah. And then, unless there's something else that prolongs that time period. Oh, I'm sorry. I already gave all the disclaimers, so subject to discoverability and all those other things.
Member.
I think the last question on this, and I understand the need to the need to reference those disclaimers as it relates to this complicated area of the law. I think the last question I would have around this as it relates to Clause 5 goes as follows. We'll take our example. The image has been posted. It's been posted for 2 years. It's an intimate image. There's no consent. The 18-year-old endures, takes no step, becomes 19, takes no. But now she's 23, and it suddenly is presenting a different problem to her in terms of securing employment, and her life has taken on a different. And the image has been posted throughout. Has she lost, through the passage of that time, has she lost the ability to avail herself of relief under Clause 5?
Minister.
Yeah, so I think the protection that person described could avail themselves of is Section 4. So the fact that consent was withdrawn for that image, that might be one way. And I think there may be some legal arguments in that regard related to continuing harm, depending on the facts. But.
Shall Clause 5 pass? So ordered. Oh, sorry.
I had one more.
Is there agreement to continue on Clause 5? On Clause 5, member.
I am eternally grateful and somewhat embarrassed given the nature of the question I'm about to ask, which I think will be the final one on this section. But I raised this with the staff, and it has to do in sub 5 of Clause 5. It's just the language, and sometimes we see this and sometimes we don't. So that this is a reg making power that allows for in sub 5. The line that interests me is the final one. After considering any prescribed factors, and the question is more of a case of legislative drafting. When we say that, does that mean, I'll let the attorney make sure she knows where I'm at here. I think she's found it. Does that today, in terms of the canons of construction and interpretation, statutory interpretation, does that mean that the decision maker can only consider factors that are prescribed? Or does it mean they can consider factors that are prescribed and anything else that they want to consider? Because when I read it, it seems fairly directive. It says there will be regulations that lay out what you may take into account, and those are the things that you may take into account, and nothing more.
Minister.
Okay, so after talking about legislative drafting and the wording, I'm assured that the intent of that wording is not to limit, and it's drafted in a sense that wouldn't limit to only those prescribed factors. It signals that there may be prescribed factors is the intent of that language. So if there will be regulation, which there may not be with this particular clause, then it may give factors for them to consider, but it's not a limiting it only to those prescribed factors the way it's drafted.
Shall Clause 5 pass? So ordered. I note that we haven't had a break, and I want to check with the minister if anyone requires a 5-minute.
Want to take 5?
Take 5? Okay. We will adjourn for 5 minutes. Recess for 5 minutes. We'll call the Committee on Bill 12 back to order. Shall Clause 6 pass? Aye. Recognizing the member for Abbotsford West.
Right, so we're now on to the, really the second new avenue for claim that the Act provides for, and that is the one that includes the possibility of an applicant receiving damages. I think maybe the general question here for the minister is to summarize as best she can the significant differences between this and the previous section and where it's injunctive relief. And by that I mean, presumably in this case for reasons that we've already discussed, there will be a respondent. There is an obligation to notify those people whom one is seeking, an applicant is seeking damages from, and the nature of the relief that can be claimed and against whom that relief can be claimed as part of an action under Clause 6.
Minister.
Thank you. So I'll start by talking about the distinctions between the two processes. So as we already went over in Section 5, that's really about an expedited order process to take down. So it's very different than the claim for damages in Section 6, and I'll point out some of the significant differences. So to start with, an individual or the public can think of this much like a civil claim for damages. So the levels of court being the Civil Resolution Tribunal, the Provincial Court, and the Supreme Court, which are available to them to make damages. The notice provisions and all of the general provisions with respect to civil claims would apply. Notably, it isn't tied to whatever the orders are in the application. It could be a broad claim for damages that are quite apart from the expedited order. And all that needs to be the basis of it is that an image was distributed without their consent. And we also left it open to the heads of damages that may be pursued in the matter that are available in our court system for civil claims. So it is very much like a civil claim for damages.
Member.
Thanks, Honourable Chair, and it's, well, all of the answer is helpful, but the last part that provides the helpful segue into my next question, which is, in a legal world where there are other available torts, other available causes of action known within the common law to facilitate a claim for damages in circumstances like this, what is the gap that the minister and the government believe exists that this particular statutory cause of action is intended to address?
Minister.
Okay, so one of the things in putting together this piece of legislation that the underlying goal was to bring clarity into some uncertainties in the law. So there's uncertainty when it comes to the unlawfulness of non-consensual disclosure of intimate images at common law. And while there is a new common law tort that's been recognized in other provinces, we're not aware of its recognition in this province. So similarly, actions of invasion of privacy, intentional infliction of nervous shock, breach of confidence, and some other torts can be onerous to argue. So what Section 6 does, it says that if somebody has, subsection 1, depicted an image, if an intimate image of a person is distributed without their consent, they may claim relief for that. So it sets out a claim for damages specifically for that act. Does that help?
Member. Yes, in part it does, because the attorney has touched on some of the existing tort law, existing torts around violations of privacy, the disclosure, public disclosure of private facts. I'm going to suggest that in terms of the clarity, if the lack of clarity related more, and it's a question, I'm sorry, I may make it as a statement, but I mean it as a question. The lack of clarity may have related more to the question of what applicable damages might be sought than the question of damages being suffered or injury being suffered in this case. I understand that the attorney says we have removed any doubt by virtue of the specificity of our definition of the disclosure of an intimate image. I'm going to suggest that there wasn't a lot of doubt in Canadian tort law that represented tortious behavior, where I thought there might be more uncertainty, and that the section seeks to bring some additional clarity is around the issue of damages and the heads of damages, as the minister put it, that might be applicable. But that's a question, and the minister may disagree with me in that regard.
Attorney.
Thanks for the question. I think the overall goal of this, because I take the member's point about it lists the types of damages in the broadest sense that are available that may be available in a civil claim. The point of this section is to bring clarity on the law that these types of damages are available to a victim of the non-consensual disclosure of intimate images. So that's the real goal of listing it out.
Member.
Thank you, Honourable Chair. And insofar as the section contemplates, the clause contemplates an order for the assessment and an order for damages, depending on the quantum of damages being sought, determines, not exclusively, but helps determine which decision maker, to use the language of the Act, the claimant must file in. Now, they can always file in the Supreme Court of British Columbia, I take it, but depending on the amount of damages claimed, they may be obliged to file in the Supreme Court of British Columbia. Is that correct?
Minister.
Yes.
Member.
And again, to be clear, contrary to the process that we've discussed at some length in in Clause 5, there's not the same dedicated attempt, and I don't mean this in a negative way. These are existing processes, whether it be the CRT or the provincial court or the Supreme Court, and by necessity, or the reality is, the Supreme Court process is more technical, more complex, doesn't absolutely require the involvement of counsel, but for many people, it's a more difficult thing to navigate. And there's no, at this stage at least, aside from the overall attempt through the CRT and others to provide access, there's no attempt in this clause of this bill to provide an expedited or easier point of entry into the Supreme Court of British Columbia for the collection of damages.
Attorney.
Yeah, that's correct. This is meant to make it clear that the individual in this matter has a claim for damages, and the member quite rightly pointed out the level that they may pursue it at, depending on the claim or the claim for damages that they seek, and that process is as it is for other civil claims.
Member.
And again, a limitation regime applies, triggered by discoverability, beyond which a claimant would be precluded from advancing a claim for damages.
Attorney.
I think it's the similar discussion that we had previously about there may be some exceptions to the limitations period that the individual may be able to avail themselves out, continuing harm or discoverability if it's still up. But that's correct. The limitation periods would apply.
Shall Clause 6 pass? So ordered. Clause 7, member for Abbotsford West.
For the in the case of an application on behalf of a deceased, can the in general terms, what would the limitation period be for someone seeking to advance a claim? Is it the same? Is it the same? Well, it wouldn't be necessarily the same. The person's deceased. What limitation regime would govern an application under on behalf of a deceased under Section 5? And is it different than? Sorry, I'm trying to lump these questions together to move us along a bit. What's for a claim being brought on behalf of a deceased under Section 5, what is the applicable limitation period? And is a person precluded from bringing an application on behalf of a deceased person under Clause 6 by virtue of other existing law?
Attorney.
So the section 7 only applies to Section 5, so it would only be for the takedown of the image or orders related to that, of the deceased individual. And when it comes to claims for damages, I think the member is correct. There's existing law that talks about the things that are available for people and or states that may be pursuing that, and limits to what can be done there.
Member.
And with respect to clause 5 then, and a takedown order, how long does from discoverability does someone acting on behalf of a deceased person have to bring that application generally?
Attorney.
So assuming that the impetus for seeking a Section 5 order is that the image is still being distributed or is available publicly, then the limitation period for it would continue. You would assume that a continuing harm would apply to that. I would say that with a disclaimer here about the law related to limitations and deceased, but in terms of the harm done or the limitations period, I think there'd be a potential ability to rely on the continuing harm of the image that's still up.
Shall clause 7 pass? Aye. So ordered. Shall clause 8 pass? Member for Abbotsford West.
Thanks, Honourable Chair. I guess the obvious question here, given the dialogue we've had as it relates to the exposure and vulnerability of younger people, the recognition that for some young people, as traumatic as it is to see a intimate image of themselves being distributed, and what that means for their peer group, it can also, the trauma can extend to what the implications are for family life at home. I take it the section is intended to provide a regulatory authority that would authorize younger people than is normally the case to initiate, or people can initiate action under these provisions at an age younger than they normally would be able to do independently. I know that the regulation will ultimately appear, but I'm sure the minister has already received some information and has got something in mind as to whether there will be what the specific age will be at which an applicant can proceed on their own or with the assistance of someone other than a parent. Is she able to share some thoughts with the committee around what she believes the appropriate age would be?
Attorney.
Thank you. So when it comes to a minor, at this stage, we intend to, after, if this legislation is passed, to actually have consultation with a lot of the frontline groups and people that are seeing this come up to determine what the appropriate age is. Sometimes what we found is that it's not necessarily 18, it may be older, maybe younger. And so we want to actually hear from people before we set that. So I don't have any further information at this point for the member.
Member.
Right. We are talking, though, about an age below the age of majority, because we're talking about minors here. So I guess the interest one would have is how low that number is likely to go. And because of I think we are all sadly aware of the remarkably young age at which young people can be caught and victimized in the way, and we have some very direct and pertinent examples of how that tragedy can unfold at a very young age. The challenge for the minister, though, in setting that age, which I suppose ultimately needs to be a number, whether it's 17 or 16 or 13, it will ultimately have to be a number, is balancing that notion that I described a few moments ago about the embarrassment that a young person might have about confronting a parent or parents versus the desire that parents would have to know and hopefully offer support and be there. And so it's not the only area of public policy where this conundrum presents itself, where the sins of society visit upon people at a younger and younger age, and you want to equip them with the means to seek redress and assistance, and yet not preclude or exclude parents from being there to play a role. So I expect this legislation is going to pass shortly and may even be in line to receive royal assent. And I'm sure the minister would like to have it up and operational as quickly as possible. So I take it the consultation is going to be swift, because she'll want to have the regulations in place quickly. And I guess my submission to her is to take into account, in addition to the need to equip young people, is to not lose sight of the fact that there are many parents out there who don't want to be left out in terms of being able to offer support, and to do that they need to know what's going on as well. Last thing then on this clause, this provision, as I understand it, applies specifically with respect to applications under Clause 5, and the usual age rules around age and ability to commence an action apply with respect to Clause 6. Is that correct?
Attorney.
Thanks. So just thanks for the question. So yes, you're correct that the regular guardianship or rules would apply to claims under Section 6. Important to just add a little bit to what I said before is that the Section 8 provisions are meant to be in addition, so it's another option. And the member had a very important comments about parents and their roles in that. And so when we think about the prescribed class of people that may be able to do this, if it's an older sibling or if it's a teacher or something, I think it's meant to be somebody that's close to the person and another option for a minor to come forward with this.
Shall Clause 8 pass? Aye. So ordered. Shall Clause 9, member for Abbotsford West.
Thanks, Honourable Chair. So whenever we are confronted by reverse onus provisions, it's worth taking a moment just to understand precisely how they are intended to operate. So here's my understanding. Rather than ask an open-ended question, I'll presumptively give the attorney how I think it operates. If I'm wrong, she can tell me. It seems to me that having read this and having regard for the definitions, what is trying to be achieved here is as follows. If an image is an intimate image such that it qualifies under the definition by depicting an individual engaging in a sexual act, a nude or nearly nude, exposing the individual's genitals, organs, anal region, or breasts. Now, except for one other component, we have an intimate image, and the other component is the expectation of privacy, a reasonable expectation of privacy. But for that final component, the burden shifts to the respondent to demonstrate that there was not a reasonable expectation of privacy. Have I got that right? That once, if we have an image that otherwise qualifies as an intimate image, then the part of that definition for which the burden shifts to the respondent is the part about reasonable expectation of privacy.
Attorney.
Yes.
Member.
No, that's fine on 9.
Shall Clause 9 pass? So ordered. Shall Clause 10 pass? Member for Abbotsford West.
So we now get into defenses available. Defenses available to a respondent. Can I say this? I have been thinking about, so Clause 10 says a respondent is not liable under Section 5 if, and then it goes on to describe. And we have been talking about Clause 5 really in the context of there not being a respondent. And yet the language suggests that, at least in some instances, there might be. Am I misreading? Am I confusing that somehow?
Attorney.
Okay, thank you. So just to go into further detail about how Section 5 is laid out. An applicant can choose to name a respondent or not. So in that situation, there may be a respondent named, so that would put them. And another situation where there would be a respondent is, let's say that somebody that's affected by an order wants to contest it. So they come forward, and that's under Section 5 as well, to contest it, then they're automatically placed as a respondent in that category. So that captures that, and then you can see how Section 10 would apply.
Shall Clause 10 pass? Sorry, Abbotsford West on Clause 10.
Yeah, sorry, I did have, that was a preliminary question. So consent becomes a really key feature of the ability to proceed with an action and a defense to an action. The Act is silent as to the manner in which consent must be given. I take it the intention here is to recognize that consent can be communicated in many ways, and a adjudicator or decision maker may find that there was verbal consent, may find that there was consent, passive consent. I was, or implied consent. In this case, I was a little bit surprised that, and again, to be fair, I don't think the working group had anything specific to say about this, but I thought that the attorney might be seeking, in the case of consent, something demonstrative, written or verifiable verbal consent. It strikes me that what we'll see now eventually are cases where the respondent says, "Hey, for the following reasons, I thought I had consent," and the attorney has left it to the courts, and I take it that is a purposeful thing, a purposeful decision on her and the government's part to leave it to the courts to decide what constitutes appropriate and reasonable consent.
Attorney.
So the short answer is, yeah, we intentionally left, did not include a definition of consent, and that the courts would determine based on the facts.
Shall Clause 10 pass? So ordered. Shall Clause 11 pass? So ordered. Shall Clause 12, member for Abbotsford West?
Thanks, Honourable Chair. Going back to the beginning of our discussion, the commencement of the clauses in the bill, we talked about how an internet intermediary, based on the definition, certainly includes the large platforms, the Facebooks and the Twitters. But I think we also established that by virtue of that definition, a website with an interactive chat room could also be captured. Is the message here that, and is it intended to establish certainty around the fact that if you are operating a website that includes an interactive platform to which people can post information or images, no matter how big or small you are, you had better make sure that you have a process in place for ensuring that you are not inadvertently contributing to the distribution of intimate images.
Attorney.
Thank you, Mr. Speaker. The purpose of this was drawn on the advice from the Uniform Law Conference, which talked about the real goal and orientation of these types of legislation, which should be on removing the harm and victim-focused. So in that sense, we didn't want it to be a lightning rod for larger claims to fight out the battles that happen between internet companies that can be long and protracted. So what this does or says is that if you take reasonable actions, your liability is limited, but if you don't, then you're not. So that was the purpose of that provision.
Member.
Yes, thank you, Honourable Chair, and a sound reminder from the attorney. And I think the point I was trying to explore with the attorney is with these large platforms who face the challenge of having millions of images posted every day, but for that reason have constructed and designed these pretty elaborate monitoring, not foolproof, I expect, but they make these investments because they recognize, in most instances, I hope, as these and similar liability provisions exist. My question was less about them than the realization. And look, you can have on a regional or localized basis a site that suddenly becomes very popular in a regional area, a website that includes an interactive. They may not have developed similar monitoring and safeguards. And I think what I was asking of the Attorney General is to confirm that if you fall within the definition of an internet intermediary, which doesn't mean you have to be Facebook or Twitter, it means you have created a platform, and it might be to sell your goods or sell your services, but or social activities or whatever. But if it includes an interactive component to which people can post, but you are now an internet intermediary for the purpose of this act, and can therefore attract liability. And if you want to avoid that liability by availing yourself of the defense available in Clause 12, you will need to establish that you have some reasonable level of monitoring. So I'm less concerned in this case about the larger centers than the fact that by virtue of the definition of internet intermediary, others may discover that they attract a liability as well.
Attorney.
So I would start by saying that in the example that the member provides, if it is a website or some regional internet intermediary, and they are involved in or implicated in the non-consensual disclosure of intimate images, then if there is an order for an individual, and I'm sure that's a scenario when it would come up, like somebody said to them, you're distributing my images in a non-consensual way, then absolutely they need to have that, take individual action for that person to take down those images if there's an order to that regard. And that would be without any complicated monitoring technology. That would just be a direct takedown, and we would expect them to take reasonable steps to do that.
Shall clause 12 through 21 inclusive pass? Aye. So ordered. Clause 22, member for Abbotsford West.
Thanks, Honourable Chair. Way back when we started, we had a conversation, preliminary conversation about the interaction between the criminal code provisions and what's being created here, and the attorney provided some initial data around the number of complaints and charges that have been laid, and how that has influenced somewhat the development of this. And I presume this is the section that makes clear that that existing process can continue. Charges can be laid, police can prosecute parallel to the pursuit of a civil claim that is provided for. So the attorney, I'm sure, will confirm that. What I wanted to ask was the attorney able to secure any additional information? I think the number she gave at one time was that there had been 22 charges. Have we had any convictions? Has anyone been convicted in British Columbia under the criminal code provisions for the non-consensual distribution of intimate images?
So that the first comment about the purpose of this is correct, but then we do have more data for you, and I'll just read it. In BC, there was 50 non-consensual distribution of intimate images charges laid. 50. 47 adults and 3 youth, and that was under the Criminal Code section 162.1, subsection 1. And in 2021, The case outcomes for the 37 adult cases were 16 guilty and 2 not guilty findings, as well as 5 stay of proceedings and 3 other, and 11 are not concluded. That's the extent of the data that I was able to provide today.
Member.
Thanks. So it sounds like along the way in the last two years, there have been 16 either admissions or findings of guilt with respect to criminal code charges under the relevant provisions.
Attorney.
Okay, that's correct. In 2021, it was 16 guilty and 2 not guilty, 5 stays of proceeding, 3 other, 11 not concluded, and that's for adult.
Shall Clause 22 pass? Aye. So ordered. Shall Clause member for Abbotsford West on Clause 23?
Honourable Chair, I'm going to offer the attorney, well, she always gets the last word in these proceedings, but I'm going to invite her to take advantage. I think this will be the last clause that I pose any questions on. It's not an unprecedented clause. It is an unusual one insofar as it dates the effective date back to the date of introduction of this legislation, which means, as the attorney, I think, pointed out somewhere along the way, maybe in her first reading remarks, if someone is out there, and we'll come back to our example, if someone is posting or has posted or is threatening to post today an intimate image of that 18-year-old girl and causing her horrendous distress and victimizing her, they best not think that somehow these provisions won't apply until maybe moments later when they, sometime in the future, I'm sure the attorney will want to make clear that when this legislation passes, as it will shortly, that anyone that has engaged in that activity since this bill hit the floor of this chamber risks finding themselves on the receiving end of an order. I'll leave it at that and thank the attorney and her staff for their participation and assistance in these committee proceedings.
Attorney.
Okay. Thanks for giving me the opportunity to talk about this. And as I said clearly, not only to the public when we introduced this, but also throughout our communications on this, is that we want to start now by deterring all of those would-be distributors of non-consensual disclosure or distribution of intimate images. This legislation is designed to put them on notice that as of the day of first reading, they could be liable for the orders and the remedies under this piece of legislation. We want the victims of this type of sexualized violence to know that we are doing everything we can in our justice system to make sure that they have the remedies and tools they need to stop the harm from this type of behavior. And with that, I just want to thank the member for the questions and the team here that were with me today.
Thank you, Attorney. Shall clause 23 through 31 inclusive pass? So ordered. Shall the title pass? So ordered. Attorney General.
I move that the committee rise and report the bill complete without amendment.
Members heard the question. That's right. All those in favor? Aye. Opposed? Carried. We'll report to the Speaker. This committee is adjourned.
Committee Chair.
Thank you, Honourable Speaker. Committee reports Bill 12 complete without amendment.
When shall the bill be read a third time, Government House Leader?
Now, Honourable Speaker.
Member, the question is the third reading of Bill 12, Intimate Images Protection Act. All those in favour indicate aye. Aye. Opposed? Motion carried. Bill 12, Intimate Images Protection Act has been read third time and has passed. Government House Leader.
What do we got next? Thank you, Honourable Speaker. I call Committee of the Whole Bill 17, Family Law Act 2023.
Committee stage. Committee Chair.
We will take a short recess as we prepare for the correct staff to be in place. All right, thank you, members. I'd like to get started with a short time we have here. We're looking at Bill 17, the Family Law Amendment Act 2023, recognizing the Attorney General.
I'd love to just introduce the team that I have here with me that'll be supporting me. We have Daryl Rennick, Legal Counsel, and Aurora Beralden, Legal Counsel. So, thank you.
On Clause 1, I see the member for Abbotsford West.
Thanks, Honorable Chair. So, three components to this legislation as it relates to the division of family assets. This is the first one, which touches upon pets and how pets are dealt with, and creates the defined term companion animal, which, according to the definition, is an animal that is primarily for companionship. I'll probably deal with clauses 1 and 2 together, since they both kind of relate to the same thing. So companion animal, and then in clause 2, we're told what a companion animal doesn't include. It doesn't include a guide or service dog, an animal that is kept as part of a business, an animal that is kept for agricultural purposes. So I suppose it's possible for us to, since we're going down this road and defining this, it's possible for us to think of circumstances where an animal might fulfill both purposes. And so by definition, this would be for families residing in more rural settings. Hard to imagine someone in downtown Vancouver having an animal that fulfills at their home an agricultural purpose. Although I suppose they have chickens now in the West End, the chair reminds me. There were two kinds of animals, two examples that sort of readily came to mind for me where there might be a crossover. One is a herder dog, which is obviously there in part for an agricultural purpose, but in most cases becomes a pretty closely aligned member of the family and a companion. So I'll give you both examples, because I guess we're going to move along here to other matters shortly. And out in certain parts of British Columbia, you may have situations where families have horses, which are more than just fulfill more than just an agricultural purpose, become pretty intimate members of the family circle as well. So those are two examples where, and there are probably others, where you can think of a situation where there'd be a crossover. How does the definition operate, or does it, to address situations where an animal is both there for an agricultural purpose, but is very much a family pet?
Attorney.
Thank you. So the key part of this definition that I want to draw everyone's attention to is the word primarily. So primarily for the purpose of companionship. And if a party in a dissolution of marriage wants to bring forward a claim that the herder dog or the horses that you mentioned as examples, or the member mentioned examples, are primarily for the purposes of companionship, they could bring that claim under and seek an order from a judge that should be captured, and then maybe there would be, if there was an opposition to that finding, then it would be up to that person to claim other categories. And then I will also note that if an animal is considered to be for an agricultural purpose, then the regular property division I guess would apply, right? That you wouldn't seek an order for it, but there would be a division as that would be considered agricultural property and has a value when it comes to that.
Sorry, I see the member for Vernon-Monashee.
Thank you, Mr. Speaker. May I seek the leave to make an introduction, please?
Is leave granted? Proceed.
Thank you, Mr. Speaker. I have some very special guests in the gallery here joining us for the first time. My maternal uncle Nishan Singh Khosa, my auntie Amarjeet Kaur Khosa, and my sister-in-law Ravinderjeet Kaur Khosa, and Adesh Khosa is my nephew, along with them family friend Vikramjeet Singh. And my uncle, Mr. Speaker, had a stroke while driving, and his car ended up in ditch a few years ago, and he had nearly 4 times near-death experiences. So for me, having the ability to introduce him, it's an amazing feeling because we thought we lost him. So he ended up with many deficits, losing speech and mobility, but he's still full of life. So his entire life was dedicated to social work and helping marginalized people. So he played a big role after my dad passed away in our life. So with the House, please give them a warm welcome and make them feel very welcomed here in the House. Thank you. Thank you, Mr. Speaker.
Thank you, Member. Attorney General.
I move that the committee rise, report progress, and seek leave to sit again.
Members have heard the question. All those in favor? Opposed? Carried. This committee is adjourned.
Committee Chair.
Thank you, Honourable Speaker. Committee reports progress on Bill 17 and seeks leave to sit again.
When shall the committee sit again, Government House Leader?
At the next sitting.
So ordered. Committee Chair.
Honourable Speaker, Committee of Supply, Section C, reports progress on the estimates of the Ministry of Environment and Climate Change Strategy and asks leave to sit again.
When shall the committee sit again, Government House Leader?
At the next sitting.
So ordered. The House will be in recess for 5 minutes. I'll call the House back to order. Committee Chair.
Mr. Speaker, Committee of Supply Section A reports progress on the estimates of Ministry of Forests and asks leave to sit again.
When shall the committee sit again, Government House Leader? So ordered. Members, her honor is in the precinct, and please remain seated while we wait her to come here.
Intimate Images Protection Act, Miscellaneous Statutes Modernization Amendment Act 2023, Vital Statistics Amendment Act 2023. In His Majesty's name, Her Honor the Lieutenant Governor doth assent to these acts. Supply Act Number 1, 2023. In His Majesty's name, Her Honor the Lieutenant Governor thanks His Majesty's loyal subjects, accepts their benevolence, and assents to this act.
Thank you very much. It's Squaichel Stedata. As always, it's great to see you, to join you today, and I understand you've had an extremely busy week and another busy week next week, but I do hope you'll have time to enjoy some time with family and friends over the Easter break. And you know, one thing that the pandemic has taught me is how important it is to express the appreciation that you feel for others without delay and without reserve. So as always, I want to thank you for your truly splendid work and to wish you all the very best always. Haichka Siam.
Government House Leader.
Thank you, Honourable Speaker. Mr. Speaker, I move that notwithstanding Standing Order 2, when the House next adjourns, it stands adjourned until 10 a.m. Monday, April 3rd, 2023.
Members, you have heard the question. All those in favour say aye. Aye. Opposed? Motion carried. Government House Leader.
Mr. Speaker, I move that House now adjourn.
You heard the question. All those in favour indicate aye. Aye. Opposed? Motion carried. This House stands adjourned until 10 a.m. Monday, April 3rd.